You smell that? Second Amendment news. Yup. Trump's big beautiful bill was signed on Independence Day, rendering the tax on making or transfer of silencers, short-barreled firearms, or AOWs no more. No changes for machine guns or destructive devices, though. Now, there's some confusion as to when this takes effect, and you gotta love how Congress words things. The law says amendments made by this section shall apply to calendar quarters beginning more than 90 days after the date of enactment of this act. Since the bill was signed on July 4th, 90 days from that date puts us at October 2nd, right at the beginning of Q4. And since the amendment shall apply to calendar quarters beginning more than 90 days after the bill is signed, that makes this effective Q1 2026. That's right, there is no date because why make it easy for people to understand? Hell, I didn't even understand it. Unfortunately, as you're likely aware, the more robust language that would have removed those items from the NFA entirely was booted by the Senate parliamentarian. You know, the person who's not elected. And the language dealing with the sporting purposes in the destructive devices definition also missed making the final cut. Now, I know a lot of you are bummed. You know what? Bummed's probably kind of an understatement here. That this didn't completely remove silencers, short-barrel firearms, and AOWs from the NFA. I am too. While this result was certainly not perfect, it is the first major reform in the NFA that had a positive result. On top of that, any of the bills that were introduced, such as the HPA, the Shush Act, and the Short Act, were unlikely to get anywhere through traditional means because of the filibuster in the Senate. If there is an upshot, other than the tax being removed, there's already been one lawsuit filed. And the Second Amendment Foundation, along with the American Suppressor Association, NRA, and FPC, are working together to bring their own challenge to the continued inclusion of these items in the NFA. Rest assured, all the 2A groups are pushing back. I'd love to hear how many of you guys are going to wait to purchase an NFA item until the tax shifts to zero. Things could get spicy for manufacturers, so let's use this as a chance to tell them what you're doing down in the comments. Welcome back to the Big 2A, the show where we bring you all the top Second Amendment stories. I'm your host, Adam Kraut. It was so great to meet many of you at GunCon the other week. I really enjoyed our conversations, and I hope you all had fun seeing all of the vendors and listening to the various panels. That said, the time's come, more 2A news. A unanimous 3-0 panel decision, get wrecked, out of the Ninth Circuit held California's firearm rationing law that allowed the purchase of one gun every 30 days to be unconstitutional at the end of June, thanks to a case called Nguyen v. Bonta, brought by the Second Amendment Foundation and its partners. Originally enacted in 1999, the law started with handguns, but over the years was amended to include all firearms, with very few exceptions to whom it applied, most notably Hollywood. Boo! Can't have those movies not being made, but hey, screw the little guy, am I right? California argued that 1. The Second Amendment does not guarantee a right to possess multiple firearms, and 2. Even if it did, restricting the frequency of purchase does not prevent someone from acquiring multiple firearms. The court rejected both those arguments. I mean, can you believe the arrogance required to argue that the Second Amendment doesn't guarantee the right to multiple guns, even though the text literally says arms, plural, more than one, upwards of many? The court takes issue with California's first argument for several reasons. First, the term arms in the Second Amendment is plural. Second, arms refers to more than just guns. And third, California's interpretation would mean that the Second Amendment only protects the possession of a single weapon of any kind. The court straight up says, California is wrong. California's second argument fared no better. The court reasoned that it previously held the Second Amendment does protect against meaningful constraints on the acquisition of firearms through purchase, and that it protects the ability to acquire multiple arms. The opinion points out that California's law's purpose is delay itself, and infringes on Californians' Second Amendment rights. In the opinion, it stated, "We're not aware of any circumstance where government may temporarily meter the exercise of constitutional rights in this manner, and we doubt anyone would think government could limit citizens' free speech right to one protest a month, their free exercise right to one warship service per month, or their right to be free from unreasonable searches and seizures to apply to only one search or arrest per month." California's litany of historical support for its rationing of firearms was also rejected by the court, finding that many of California's proposed historical analogs impose no burden on an individual's ability to acquire, keep, or bear arms. For example, the laws requiring dealers to register and track sales do not burden the purchaser. The court concludes the Second Amendment expressly protects the right to possess multiple arms. It also protects against meaningful constraints on the right to acquire arms, because otherwise the right to keep and bear would be hollow. And while Bruin does not require a historical twin for modern firearm regulation to pass muster, here the historical record does not even establish a historical cousin for California's one gun a month law. It's not often that we see the Ninth Circuit rule in favor of the Second Amendment, but when it does happen, it's quite refreshing. Moving on, North Carolina is not getting permitless carry, also known as constitutional carry. Late last month, Governor Stein vetoed Senate Bill 50, which would have made the Tar Heel state the 30th state to adopt permitless carry. In his veto statement, the governor said, "This bill makes Carolinians less safe and undermines responsible gun ownership. Therefore, I am vetoing it." The bill eliminates training requirements associated with concealed carry permits and reduces the age to carry a concealed weapon from 21 to 18 years old. The governor also said, authorizing teenagers to carry a concealed weapon with no training whatsoever is dangerous. The bill would also make the job of law enforcement officer more difficult and less safe. We can and should protect the right to bear arms without recklessly endangering law enforcement officers and our people. If you don't remember high school civics, the state legislature could override the governor's veto. In North Carolina, it would require 3/5 majority in both chambers. And with the composition of the legislature, it would require some Democrats to cross the aisle in order to make that bill become a law. Of course, we well know permitless carry doesn't turn states into the Wild West. This bill and laws in other states still have requirements that people have to be eligible to carry a firearm, like not being prohibited. The public is not any less safe in states that enacted these types of laws, but hey, let's not let facts get in the way of feelings. Next up, Rhode Island has implemented an assault weapons ban, making it the 11th state to do so. While the original version of the law included registration with the police, that was apparently a bit too controversial. Go figure, right? The final product focuses on the manufacture, sale, transfer, and purchase of any prohibited firearm. And, as you might have guessed, that does have a definition. A prohibited firearm was defined to include semi-automatic shotguns with fixed magazines capable of holding more than 6 rounds, any shotgun with a revolving cylinder, and any semi-automatic pistol or rifle with a fixed magazine capable of holding more than 10 rounds. It also incorporates the features tests found in most assault weapons bans, which includes any semi-automatic long gun that accepts a detachable magazine if it has an adjustable stock, bayonet lug, pistol grip, grenade launcher, barrel shot, the thing that goes up, thumbhole stock, threaded barrel, or can accept belt-fed ammunition. And the penalty for a violation? Just a mere 10 years in prison. The new law goes into effect July 1, 2026. Hopefully by then, the Supreme Court will have taken any number of the pending assault weapons ban challenges working their way toward the court and render this law null and void. But it's not all bad news, at least outside the Northeast Corridor. South Dakota's newest addition to its carry laws will allow carry on college campuses, and it started July 1. The new law will allow students, visitors, and school employees to carry concealed on campus if they have an enhanced or restricted enhanced concealed carry permit. That's right, restricted enhanced. Whatever that means. On top of being able to carry a pistol, the law also permits individuals to carry a stun gun or mace. Not a mace, like the pepper spray stuff. Seeing young adults being encouraged to protect themselves with a firearm is something that we really like to see here, and overall, that's good news for gun rights.